Now, since we have no prescribed form, and I'll give you just an exemption, in case some of you people may have heard of an exemption called an offering memorandum exemption. It doesn't exist in Ontario. They do have rules, like in the Western provinces, that have what's called an offering memorandum exemption that lays out what's supposed to be in the document. But those don't apply to Ontario, so I won't deal with that. I just want to mention that in case you understand that and you avoid any confusion. In terms of what is required in Ontario, we have to have in the document what are called statutory rights of action. And it essentially, by statute, gives a person a right to sue if there's a misrepresentation. Some jurisdictions don't have that. So in other words, you would have, if you did this across Canada, you'd have one jurisdiction that would not give that right. They could sue under common law, but it wouldn't be in the statute itself. So what often people do is they essentially include statutory rights of action, and they call them contractual rights of action. In other words, if I'm in Ontario and Jonathan's in another jurisdiction that doesn't allow it, they'll say whoever's a resident of that other jurisdiction will have the same rights as an Ontario investor, and everybody's treated as on the level playing field. And that's basically a commercial decision. So if I have someone like Kumon coming to me and saying, Brian, we want to offer this thing in Canada, how are you going to do that since you have no form? What we would do is we would put together what we call, in legal jargon, an OM wrapper, an offering memorandum wrapper. And really all it is a couple-page document that would be affixed on top of that offering circular that we got from that foreign jurisdiction. It would include the statutory rights of action and have some of the basic things that would talk about the issue. But essentially, we wrap in that document to be part of this thing, and it forms part of it, so it becomes one document. And the issuer would sign it saying there's no misrepresentation. So other than that, I've seen some OM wrappers have tax disclosure, some don't. Obviously, there's a signature page. In terms of a Sukuk issuance, there would likely be a bankruptcy, insolvency, or an enforcement risk factor that would be more prevalent, like if this was established in the GCC, the ability to enforce, it would probably be in the main document, but in case it needed to be particularized in a Canadian jurisdiction or contrasted to Canada, I could see them including that. In terms of forward-looking information, when it talks about assumptions and other things that would be in an offering memorandum, in Ontario, we used to have rules that specifically required it to be applied to non-reporting issuers and non-public companies, such as a private Sukuk coming here. They have, I'd say the last year or so, they've taken them out because they've had a lot of problems with people complying with it. But generally, you'll find that what are called the forward-looking information rules, which says there's forward-looking information in this document, there's certain risks and assumptions, or what's called future-oriented financial information. They have to be reasonable, et cetera. They usually follow that standard anyway. So I think what you're getting from is, even though there's no prescribed form, people are importing a lot of what the practice is to have a good document. Now, in terms of the resale rules, is once the Sukuk is issued in Ontario and an investor has that certificate, they just can't sell it to anybody else. Again, we operate in that closed system. You can only sell it in pursuant to another prospectus exemption, or, for example, if that company becomes a public company, and they're called resale rules. And typically, they are 4 months, 4 months and a day. So I don't think that would be applicable here, only in the sense that I believe that if one does a private issuance from a Sukuk, it will always be caught and can only be sold in the exempt markets. And lastly, in terms of who can sell it, obviously we have a registration regime in Canada. Anybody just can't go out there and sell securities. There's various definitions of what triggers registration. But generally in Canada, what I would see is an investment bank or possibly even an exempt market dealer. In Ontario, they used to be called limited market dealers. Those are two registrants that would probably be involved in selling this to institutionals or other type of investors. Okay, now I'm segueing into the CNSX, the Canadian National Stock Exchange. They are a recognized stock exchange in Canada that directly competes with the TSX group. Now, obviously, the TSX is much larger in many ways than the CNSX, but the reason I wanted to focus on them was that they do have specific Sukuk rules that are proposed and out there. And I thought, obviously, for a conference like that they should get a little bit of focus and highlight what they are. Not that they're extensive, but it is a step in the right direction, that they're cognizant of the fact that they may have to accommodate or do certain things to allow Sukuk to trade on their stock exchange. The bottom line in terms of being eligible to list is that they're assuming that when you come into that stock exchange, you are already a public company. And that's what they require. They have fewer rules and regulations as opposed to the TSX, and their costs are generally cheaper. But today they have no specific debt issuer requirements, and they generally follow the equity security requirements. Now, these proposed amendments came out in October 2009, and what they've done is they've set up this new Appendix B that basically sets out disclosure for debt securities. And they have a net asset requirement, and it's very low. It's net assets of at least $1 million. I mean, any Sukuk I've seen, these things are so low that it'd be easily to qualify. And they may look at on their special purpose vehicle exception they would look at the underlying assets of the originator. In terms of an asset-backed security, I know we talked about asset-backed and asset-based. So just to be clear, in an asset-backed structure, there'd be a true sale. All the assets are owned in the Sukuk, and they'd be able to do really what they would want with those assets and that type of structure. So what they're looking for is that you have a trustee or other independent representative to represent, in this case, we're talking about Sukuk holders, and an independent custodian. And in terms of further asset-backed requirements, they want to make sure that the person who's appointing and managing the pool of assets has expertise and provides periodic reports on the performance and credit quality. And it could be simply, most of these Sukuks are rated by rating agencies, they continually provide an updated rating report. And lastly, I'll leave you with proposed CNSX Policy 10. They call them specialist securities. And this would be notable to our Shariah scholars who are here, is that as they refer to Shariah-compliant securities, it must have a Shariah supervisory board. They want at least 2 members, so you just can't have one person. And in terms of the disclosure, they want about the board, names, qualifications, experience, expertise, etc. And then at the end, they just want to be delivered to them in terms of documents that would be required to be filed is the fatwa or the pronouncement saying that it's Sharia compliant, only because if there's going to be posting on their website, they want to make sure that it had received this recognition by the Sharia scholars. So with that in a nutshell, these are 2 aspects of select securities issues if a Sukuk was going to come to Canada. With that, I'd like to hand it over to my partner, Jonathan, who will talk about some leasing and personal property matters.
My focus is going to be looking at personal property sukuks, and my specialty is very much in personal rather than real property. And the takeaway that I'm hoping to leave you with is that your imagination can drive what you want the sukuk to look like, and the law isn't going to interfere that greatly in what your imagination would like to bring. The one nice thing about the Canadian legal personal property environment, particularly with leasing, and is that there are not a lot of statutory regulations. And I think the reason I was attracted to this particular area is, unlike Brian or John, where they have these very large books they have to read to understand the law, mine has nothing. So I can make it up as I go along, which gives the terrific advantage that when you're developing one of these structures, you can also, quote unquote, make it up. There are common law principles, obviously, that you've got to follow, but it's not tied into a statutory requirement. This differs than in the US, where you have Article 2A, which has a code on what a lease must look like, what it must contain in order to get certain protections. Canada looks at it strictly from common law principles. So really, we're going to try to build what you need. I've built a model here which is more of an asset-backed model as opposed to an asset-based model. It's a traditional model based on a securitization. Lease securitizations in Canada really, which is similar to, not the same as, but similar to a sukuk, is you take a series of personal property leases, you move them into a special purpose vehicle, and there's investors in the special purpose vehicle who obtain the benefit of the leases. The revenues paid from the lessee up to the special purpose vehicle, or in this case, the sukuk, and the investors obtain the benefit from that.